The Supreme Court has been hearing the Trump v. Cook case. Walk us through kind of your assessment of what's going on, what went on, and then finally kind of what it might allude to in the future.
So this week was really the big bounty of Supreme Court decisions coming down. Key one of those earlier this week was a decision that I think opens the floodgates to future kind of rulings on the broader picture of the Federal Reserve, the monetary structure, everything along with that from the federal government's perspective. That's never really been opened up in the 110 plus year history of the Federal Reserve as an institution since the Federal Reserve Act of 1913. So we're going to find out over the longer term how this whole series of events plays out. But this decision, which was specifically regarding the issue of the president's executive power to remove an FOMC board of governors seated official for cause. This is really just opening up the can of worms, in my opinion. So, to make the long story short, nothing happened, but then everything happened, right? Nothing happened. I say that in terms of the status quo was maintained, which was just upholding a prior injunction from a lower court to block that removal process of Lisa Cook being removed from that FOMC board seat without due process. Nothing really changed there. The Supreme Court just narrowly upheld that right from the seated official to, I guess, like state their case, maintain due process of law, all of that. But the bigger picture is, in my opinion, embedded in the dissenting opinion. We'll get that in a second. But just given the rapid evolution that our work view holding at the structural layer to the monetary system in our times, like States, but then also internationally with that transition from the old offshore dollar we talk about, we'll get to down the road towards the stablecoin dollar framework. Um, I'd say expect this Cook v. Trump decision to be just the first of several cases that opens up this broader topic of legal debate in the years ahead. So um, yeah, let's get into we talked about upholding the employee, or I don't know if you'd be considered an employee as a board member, right? But your right to due process. What I actually think will be the lasting repercussion here, most impactful in the long term, will be the dissent, specifically what is embedded in Justice Clarence Thomas's 21-page dissenting opinion. So what this does is now, if you think about the chain of Supreme Court official opinions that other, future, and future matters that arise before the court. These opinions, whether they're the majority opinion or dissenting, could be like a confirming or alternate opinion on either, pro or con, what have you. These form like a paper trail, a track record that future judges can cite on those matters as they come to the attention of the court. So I noted the Federal Reserve Act, the institution itself, it's never really made its way before the court in over 100 years. It's kind of by design. We're trying to, or we've been trying to kick the can uphill, and we'll do things in times of need, legislate, judicially, et cetera, to just maintain the status quo, or just move things along so we don't have to let things go, or fall apart, if they will. We do what needs to be done, kind of what's the right word, reactively as opposed to proactively, I think, is the case for people involved in this process in Washington, D.C. Just my opinion.
Yeah.
But as we go through like this process, we talk about the monetary transition underway. I think what we just saw, and specifically in this dissenting opinion that we have up on the screen, just the first page, this is ammo for that process as it unfolds. It may not be, these same justices. You're going to have natural people leaving, retiring, et cetera, on the Supreme Court, new justices appointed, new matters will arise as kind of society, government, all of us, like everything, like these issues, like what can't continue to stand without some ruling or some establishment for future stability. These will get pulled in on those topics. So some things I want to call out here. So first, Justice Thomas notes that this decision to uphold this injunction that we talked about with in favor of Lisa Cook, um, this is the first in constitutional history that the Supreme Court has stepped in blocking the executive from removing an officer of a like a quasi public institution or a government agency, that's that sort of thing. So this just hints doing something special here. We're doing something novel for the first time. I want to make sure we're taking note of that as we you know look to what's going on in this Cook v. Trump decision. I said nothing changed, but in reality, Clarence Thomas is pointing out, oh no, you are actually changing things. Second, he points out this inconsistency that an independent Fed exercising its own executive power without presidential control, like ultimately the chief executive of the federal government. Um, Ultimately, those are arguments against the Constitution, right? Separation of powers, all these enumerated powers that go along with the office of executive. Third, the majority opinion provides some selective insulation for the Federal Reserve that's not coherent. It is incoherent and violates those same separation of powers principles. And fourth, and this is part of the majority opinion's ruling, but Justice Thomas rejects this framing of the FOMC board member seat or any public office seat for that matter as Lisa Cook's property, right? These seats, these aren't heirlooms. You can think about it, same thing, a senator seat, a congressional seat, agency head, or roles, appointees, all of that to this federal government, like bureaucratic, blob, right? These aren't fiefdoms or heirlooms being passed down between individuals or families, etc. Justice Thomas really points out that idea itself is not consistent with the Constitution, the framing, what the revolution was fought for in the first place. So he's really bringing to light, he's bubbling up a lot of key issues to the surface that are not just kind of tantamount to this monetary transition we talk about. Like, oh no, this goes bigger. This is how we have come to address politics, governance, a rule of law amongst elites or families themselves, who I think if you look at traditions, right, over the last, let's say, half century to a century, if you just roll back the tape, we've seen examples of families like Clintons, Bushes, etc., like dynasties, all of that. I think Justice Thomas is really getting something here, getting to the heart of the matter, and as it usually goes, money as a central feature in the role it plays in society. That whole sore spot that is kind of exposing itself and coming to the surface in American society more broadly. I think Justice Thomas pointed it out here perfectly. And then lastly, Justice Thomas in this dissent just injects a deep history of the Federal Reserve itself and its roots as an institution derived from kind of more of a European autocratic or elitist family tree. And that structure itself is inconsistent with the American systems framework or our constitutional principles. So this 21-page dissent is huge. Yes, it's on the losing team in this battle, but just getting this thing into that archive, into that record for the future battles, I think this was the actual longest lasting impact, I think, coming out of this Cook decision and the matter more broadly as we go through this kind of process over the coming years, right? This is going to take time, but it's brought all of these, underlying kind of wounds from like the superficial level and brought them all to the surface.